Good morning. I call the meeting to order. Before the meeting, notice has been sent by the Secretariat to inform members that at the end of the nomination period of the Deputy Chair of this Bills Committee, they have received only one nomination, which is for Mr. Dominic Chan. He was nominated by Mr. Alex Fan and seconded by Nick Chan. Under paragraph 8D of Annex 4 of the House Rules, if there is any valid nomination for the post of the Deputy Commission, the Bills Committee may decide whether to elect a Deputy Chair in the meeting. Do you want to elect a Deputy Chair? Thank you. I now declare that Mr. Dominic Lee elected Deputy Chair of the Bills Committee. The administration has come in to join us already. In relation to the background information, please refer to the papers set out in the agenda. The first one is Legislative Council, reference number CPA 3/00/18C. There is the Legal Service Division report, paper number LS42 of 2026. And the background information prepared by the Secretariat, paper number CB bracket 3948 of 2026 bracket 03. Before we start discussion, I'd like to ask members whether they think there is a need to invite the public to make submissions on the bill. I see that members indicated that there is a need to invite submissions. A notice will be posted on the LegCo website inviting members of the public and the 18 district councils to make submissions. The submissions received will be forwarded to members for reference and to the administration for response. Legal Advisor's letter. The legal advisor has sent a letter to the administration asking for clarification. Paper number CB bracket 3948 of 2026 bracket 01. The first batch of the administration's reply has already been given to members. It is paper number CB bracket 3969 of 2026 bracket 01. We're waiting for the remaining batches of response from the administration. We now first discuss the policy of the Bills Committee. We will hear from Ms. Lauren Chan, Deputy Solicitor General Policy Affairs of the Department of Justice. Members, if you'd like to ask questions, please press the Request to Speak button. After we have heard from Ms. Chan, I will ask members if they'd like to ask questions. For now, each member will have 4 minutes, question and answers included. If need be, we may ask the administration to provide written reply on matters that members think requires a written reply. We hear from Ms. Chan. Thank you. To improve the existing legislation, the government has been using omnibus bills to tackle miscellaneous amendments to various enactments. They are mostly largely minor, technical, and non-controversial for updating and improving enactments. This arrangement dispense with the need to find time slots for individual amendments. This practice has been used by us to improve the legislation of Hong Kong. Under the Miscellaneous Provision Bill, we also make adaptation of law amendments and to repeal obsolete references. In 2024 and 2025, we have introduced omnibus bills tackling over 200 pieces of legislation. I think we have reached milestone success in our exercise. In this bill, there are 490 clauses covering 150 pieces of legislation. There are two types. Most of them arise from the systematic review of statutory laws of Hong Kong, covering about 77 pieces. Most of them are related to adaptation of law. There is another category. They are not arising from the systematic review. That involves about 7 pieces of legislation. For those related to the review, we will hear from the Permanent Secretary. Thank you. Now we will hear from Mr. Wesley Wong, Secretary of the Law Reform Commission. This is the 3rd consecutive year in which the Department of Justice has introduced a bill to handle adaptation of law. I'm very glad to have the opportunity to participate. I'll take this chance to present to members about the background of the amendments arising from the systematic review. Later on, the bureaus in charge of the amendments will be in charge of explaining the amendments and to answer questions. In 2022, the LRC took the lead to conduct a systematic review of statutory laws covering 3 areas. First, adaptation of laws, consolidation of laws, and to repeal obsolete laws. In relation to the adaptation of laws, they have been given the priority. To complete the work as soon as possible, the administration has made use of different ways, say for example tackling easier ones first to deal with the exercise in an orderly manner. In addition to those proposed by bureaus and departments, the Department of Justice has also made use of omnibus bills to deal with a number of legislations under enactments. This is to dispense with the need to find time slots to handle individual amendments. This will, in turn, enhance efficiency. The Department of Justice in 2024 and 2025, on behalf of different policy bureaus, introduced 2 omnibus bills covering over 100 pieces of legislation. Most of them are related to adaptation of laws. I thank the LegCo for their support. The 2 bills have been passed. We have taken stock of our experience. We now introduced a bill to amend 150 pieces of legislation covering 490 clauses. Over 130 pieces of legislation arise from the systematic review. 77 of them are adaptation related. We have adopted a more systematic way to deal with the amendment to enhance efficiency. However, we encounter different difficulties and challenges. Say, for example, for some references or provisions that require adaptation, they are rather hidden. It takes a lot of effort to identify them. Say, for example, the wording used in existing laws, and in the process of verifying the information, the words with a shade of colonialism has not been obvious. Say, for example, subject, Seal of Hong Kong. Most of the proposed amendments are related to terminology or are technical in nature. Only a minority of the provisions required rewriting. However, it still takes time to conduct a thorough historical and policy background. We also have to make reference of overseas provisions of which the existing laws are based on. It's only after the painstaking exercise that we can finalize the instructions. In the process, the Policy Bureau in charge will have to consider an array of factors, say, for example, taking into account the original legislative intent of the provisions, the interrelationship with different provisions, cross-references to some other legislations. The policy bureaus and departments will give us input on policy or operational issues. We also take into account consultation response from relevant parties. We have been doing coordination between departments and bureaus as well as the relevant division of the DOJ. We want to provide efficient support to BDs. We maintain good communication with the central authorities or parties outside the government to make sure that the progress is on schedule. We are confident that we can introduce another omnibus bill to tackle the Chinese reference of Crown, Governor, Minister, Commonwealth, United Kingdom, and Her Majesty. We want to complete our adaptation of laws on schedule. We've decided, as a result, to introduce another omnibus bill to handle all identified provisions that require adaptations. Say, for example, a number of subsidiary legislations we have identified for this purpose. We expect that there won't be much outstanding references or provisions that will require adaptations, or it's not suitable to include them in this omnibus bill. We think that there is no need to introduce another bill to handle adaptation. We can meet the goal of completing the adaptation of laws before the end of this term of government, that is the 30th of June 2027. We'll carefully continue with our exercise and make use of technology to complete the complex task. As far as we understand, that policy bureaus and departments have plans to introduce further amendments in the form of committee stage amendments at LegCos. The BDs will further elaborate and provide explanation at the right time. I believe that if this bill is passed, what remains are court practices and rules. The relevant bodies will be able to introduce subsidiary legislation by negative vetting to make the changes. As a result, there is no need to introduce another omnibus bill before the end of this term of government. There are numerous amendments scattered over different enactments. In addition to the amendments arising from the systematic review, there are also amendments required say for example, repealing obsolete provision and references. You may refer to the legal brief sent by our department in June. This is an important step to complete the adaptation of law exercise. I'm very glad to see that starting from 2022, we have been given support from BDs that facilitate our work. So it's very likely that we are able to complete our goal before the end of this term of government. We'll be happy to answer questions in relation to the proposed amendments. Thank you.
Thank you. Members may now ask questions. As I said previously, 4 minutes each for both questions and answers, and you may request for another round if there are further questions. First, Ms. Carmen Khan. Thank you. Good morning, Madam Chair. Thank you for the introduction. I believe that the Omnibus Bill can really show that as long as we're willing to work on it, we'll succeed. And this is the third time during this term that we are able to work on such an Omnibus Bill. I would like to thank the administration and the Law Reform Commission. We know that we are looking at many amendments this time. My question is that in paragraph 7 of the paper, well, as there are no other, if we're not, some of the adaptation of law is not included, some is it that it is anticipated there should not be another Omnibus Bill, so it is expected that we'll be able to complete it this time. So are we to assume that after this round there is no other need for us to amend the miscellaneous provisions in the statute law? I have read through the papers. In a March meeting at the AJLC, we said that we can also include a part of it into the Omnibus Bill, but I see that in Cap 159, this amendment proposed is based on the advice given by the Law Society of Hong Kong, and to replace Simo Lassie with Lassie and Jomo Lassie barrister to Dai Lassie. I just want to ask about this. Well, is the stance of the DOJ the same? If there is no change, why is there such a proposal? Secretary, well, thank you for your question. Our target is to hope that we'll be able to deal with all amendments of the adaptation of laws of the bill and in the subsidiary legislation. So only parts of the subsidiary legislation will be left unchanged because they could go through negative vetting, and therefore there is no need to hold another round of amendments. We have proposed the amendments, and we will continue to review the bill. The relevant departments and bureaus can share with you how they can improve further. And we would try our best to handle all the amendments. I'll defer my second question to Ms. Chan. Ms. Chan, please. Thank you, Madam Chair, and thank you, Ms. Khan, for your question. Previously, in the discussion at the panel, we proposed the amendments made to Cap 159 to include those under the Statute Law Miscellaneous Provisions Bill 2026. We stated in the panel meeting that we have to ensure that we consult the bureaus not related to Cap 159. We have received comments that there needs to be more preparation done before we can bring them up for further amendments. At this stage, we're not going to just stop here. We will continue to liaise with the Law Society of Hong Kong. We have not stopped our review because such a change would make major changes to legislation and subsidiary legislation. We need the approval of the DOJ and therefore from the CJ, and of course we would try to move this as fast as possible, and this is the current progress as of now. Madam Chair, so if we really are to make amendments, we don't have to go through the Statute Law Miscellaneous Provisions Bill 2026, as this would be the last round of amendments. We could also do this via a different channel. Am I correct? Yes. We are not going to limit ourselves to just the statute law bill. Mr. Thomas So. Thank you, Madam Chair. I am in full support of the Statute Law Miscellaneous Provisions Bill 2026. I see that we are mainly going to effect miscellaneous amendments to update our legislation. After listening to the introduction given by the Secretary, I do have a suggestion. We've seen that amendments usually are made in a passive manner. That relevant bureaus may raise amendments and then refer to the DOJ to propose amendments. So this is quite passive. I have a suggestion. Therefore, should we actually adopt a more active initiative instead of staying passive, to stay close to updates and different circumstances? Can we, for example, do some sort of review every 2 or 3 years? I noticed that Macau has been taking this initiative. I believe that we should try to do the same and not just say that we adopt the common law and others adopt the civil law and not do the same. We could set up a review perhaps every 2 years or at a frequent occurrence to see whether new amendments need to be made, and then we can bring this out for discussion. I know as of this moment we have to wait passively. We want to enhance efficiency, and therefore I suggest that we take the initiative. I noticed that in the Digital Policy Office was established in 2024, and now we have the Commissioner for Digital Policy replacing the Government Chief Information Officer. And these are proposed amendments. But then the annex may not be changed at the same time. And then for some of the officers of the in the English names, for example, we see that, for example, 局長, it's Director of Bureaus. I see that we're still using Secretary. Also, these are some of the differences that I have identified. Would we follow up on that? My conclusion is that adaptation of law is very important. However, as I said, we are quite passive at the moment. Can we be more active and take the initiative? Would the administration consider taking active initiative? Secretary, please. Thank you. In 2020 or in 2021, the Secretariat of the LRC began with the systematic review to take more active approach. The Secretariat will identify overdue legislation, and of course we prioritize those that do not conform with the basic law or with the Hong Kong SAR. And so we do adopt an active approach to identify such issues. And during the progress, it involves the relevant departments and bureaus, because how the legislation is adopted is up to those departments, and it may involve a number of bureaus. Therefore, it is up to the relevant bureaus to request changes to be made, and then we would try to amend the legislation. The last policy address mentioned artificial intelligence, and of course we would also set up a cross-departmental department to look into the use of technology, because some legislation may involve many different bureaus, and so we must work together to conduct research, and sometimes it may not take huge amendments. It may just need minor changes, and therefore we are taking an active approach in amending the legislation, and we prioritize adaptation of laws this time. And so the content of this change now currently is only on adaptation of laws.
Mr. Dominic Lee. This bill covers over 100 pieces of legislation of over 400 clauses involving many different government departments and bureaus. It's the first time I've seen so many of them here. We really appreciate the hard work you have taken. We also hope that you'll be done with the exercise once and for all. I understand that this amendment is mostly technical. There won't be any change to policy intent, basis, or contractual matters. Is that right? I may have some further questions during clause by clause. When you said in your reply, you mentioned that you will consider whether legislative amendments may affect the operation of the operation. Have you identified any actual examples? Secretary, thank you for the question. It's very rare that that happens, but it does happen. It's been so many years since the reunification, the operation of certain legislation may be different. Say, for example, issue of pensions from the Treasury. In the past, there was no cross-boundary payment methods or electronic payment methods. So the provisions are outdated. We can bring it up to date very easily. But there may be other examples. Say, for example, giving in specific instructions to law enforcement agencies. The current approach is an umbrella notification without having to direct the notifications to individual departments. The practice is different from what was done in the past, say, for example, a century ago. This time round, there are no amendments that has a retrospective effect, so there is no need to worry. Second round, Ms. Carmen Can. Thank you. I want to ask something about 12C, that is, references to mainland China and mainland of China. In Chinese, it is going to be replaced by Chinese mainland, 中國內地. I recall when I was first involved in the Miscellaneous Provisions bill, I was one of the advocates of a uniform approach for this change. I'm glad to see that the government has picked up the remaining ones. Say, for example, page 36 in Annex B, there are two proposed amendments. The word mainland China will be replaced with Chinese mainland. I'm very glad to know that they are doing it. According to information paper, the word 大陸 China is in relation to matters involving Taiwan. I would like to know that after this amendment, if we see 中國大陸, this Chinese term meaning Chinese mainland, it will not be in relation to Hong Kong because they've already completed all the changes. If the term remains, that means it's related to Taiwan. The administration talked about the numerous amendments. There is one amendment relating to the evidence ordinance, Cap 8. I noticed that there is a series. There has been a series of amendments in the past, and this time there is one. Can they be consolidated? Say, for example, well, I would like to understand what are the considerations for making the amendments in two bills. The first question is in relation to the term Chinese mainland, 中國大陸, and also the consolidated amendment under the evidence ordinance. Secretary, I thank Ms. Khan for her kind words. Well, it gives us a chance to explain. If we do a search in the e-legislation, even after this time, we still find a lot of provisions with the word dialogue. That is not in relation to Taiwan or Hong Kong. It's in relation to the location of mainland. In English, there is mainland in the in the lowercase and mainland in the uppercase. We are confident that after this exercise, after this bill, we will have tackled these issues. When the word 中國大陸, Chinese mainland, is used, the meaning is clear. Our proposed amendments will be in line with the official term and its use. Regarding the amendment of the evidence ordinance, they are all in relation to adaptations. That's my understanding. The proposed amendment to the evidence ordinance is in relation to hearsay evidence. It's also a proposal of the LRC, a previous report about relaxation of relevant criminal cases. It is part of a law reform. That's why they are separated, because they involve different policies. I understand that it is not easy to handle the exercise of making amendments to the word mainland of China, 中國大陸, Chinese mainland, and there is also the uppercase and the lowercase. Could you please conduct another exercise to see whether there are other terms that are not related to Taiwan? Give us a list so that we'll know that if changes are made in relation to 中國大陸, Chinese mainland, then these are the ones, and the remaining ones that are not on the list are in relation to Taiwan. About the evidence ordinance, there are some of us who are members of the Bills Committee on the Evidence Amendment Bill. We understand that the purpose is different. The part relating to the evidence ordinance in the bill is in relation to adaptation. Say, for example, the change of term from 立法局 to 立法會, which is the Legislative Council. But what about timing? If the two have different time schedule, then it may not be neat. I just wonder whether these will be incorporated in the evidence amendment bill. You're going to move committee stage amendments. Will you consider consolidating them? You don't have to give me an answer now. Ms. Khan's question is valid. So in relation to the list, table, the information asked for by Ms. Khan, please give us a written reply. Thank you. Next is Mr. Augustine Wong. I heard from the Secretary that the bill contains around 490 clauses covering 150 pieces of legislation. It's hard work. I would like to also thank the legal advisor of the LegCo. The legal advisor has asked a number of questions, spotting issues that are missed by the Department of Justice. I have a question for the DOJ. Any chance that there are some missing issues? Can you tell us whether there will be further amendments? So from your estimate, any chance that you've missed out anything? Mr. Wong. I would like to give due recognition to the work of the legal team of the LegCo. They have asked us some valid questions. From the reply, you learn that we have accepted some of their recommendations, whereas for other issues, we'll need time to handle them with care. We want to do our best. We hope that with hard work, the final version will not have any glitches. As I said, we have to set a date in the Gazetted. After Gazetted, we have not stopped our work to keep screening and reviewing the provisions. We have incorporated all those that require amendments and will continue to do so. Our goal is that we don't have to introduce another bill before the end of this term of government. Thank you. Next. Again, Ms. Kan. I only have 2 more questions on policy. The first one's related to what Mr. Thomas so said. Changes of functions of government departments. Say, for example, OGO is to be replaced with a commissioner for digital policy. The DPO Digital Policy Office has been established. The amendment in 2024 has seen similar changes. And this time, the Transport and Logistics Bureau has proposed some amendments. Is it the case that they have missed them in the last exercise? Apart from this kind of snagging work, I'd like to say this. When it comes to changes of the post title, is there a simpler way so that when there are changes in government job titles, there is no need to change the law? This time, in relation to the Commissioner for Digital Policy, I know that it's in relation to change in functionality, say, for example, those relating to innovation and technology. But this time, we only see the change in the title without change in the function of the government. Is it because it's not involved at this time? And in 12F of the LegCo brief, it says that when it comes to country or territory, there is a need to expand the scope of the coverage of place. Is there a policy need warranting this change?
All right, so 3 questions. So perhaps Deputy Solicitor General. Thank you. Well, on title, this is similar to what we do usually. So for non-controversial amendments, then we would put this under the miscellaneous provisions. The relevant departments and bureaus will raise this to us. So this is our usual practice. As to when we can roll this out, it will depend on when the bill will come into effect. We already have a mechanism to handle this. We thank Ms. Khan for your suggestion, and we would continue liaising with the relevant bureaus. All right, a question on places. Well, in the beginning, very often there may only be names of the place, so we would use country or territory. But then when we translate it to Chinese, then country refers to 国家 and territory, 地區. If we only look at the Chinese term 地區, there may not be any issues. But then the term territory may involve sovereignty, and therefore, in order to avoid controversy when it involves areas in which there is no sovereignty, then we would use the term place. So therefore we would use country, territory, or place, and therefore for place we would translate it into Chinese as 地方. We cannot make all the changes in one go because we have to see whether the legislation includes other places outside of Chinese mainland. So when we're talking about other countries or other areas of other countries, then we will not need to add the term place, 地方. We would have to work with different bureaus and departments on that. So this is the same method that we adopted in the 2024 and 2025 Statute Law Miscellaneous Provisions Bill. Thank you. Madam Chair, well, since there are so many considerations, when we look at the clause-by-clause scrutiny, then we would see whether it is suitable to have the term place. All right, so when we reach that part of the bill, I would like the relevant departments and bureaus to point this out so that it would be easier for us to discuss. Well, I have a question as well. First of all, I'd like to thank the administration, the LRC, all the relevant bureaus and departments for taking upon this historic mission since 2022. 2022 may not seem very long ago, but we have to handle a large number of amendments, and I really like to express my gratitude to all of you. I see that we are now conducting a systematic review, including adaptation of laws, consolidation of laws, and the repeal of obsolete laws. We are now in the third round of our systematic review, and this time it's more in-depth. We are also looking into trying to make the legislation more easy for the public to understand. And we also adopting technology to identify issues. So my question is that since we continue to review and we use different ways to make adaptations or consolidate the laws, when we adopt AI or technology to identify these legislations, does it mean that in the future we would need to enhance the technology we use to handle more difficult issues? The Secretary has also mentioned the use of AI. So this is my first question. The second question is on making legislation more easy for the public to understand. In the e-legislation database, I remember that members have suggested cases being more easily understandable, such as having more explanations. In the future, would you be able to do something about this? And then the third question is that there are some penalties that are listed out in levels. Well, from the public's point of view, they wouldn't know how much the fine would be at the different levels. And actually, when you make this change, nobody would know how much the actual figure is to be fined. Would there be any note or footnote in the e-legislation database that when you click into it, you'll be able to see the amount of fines immediately? Secretary, let me take the first question. The LRC, DOJ all embrace the use of technology to enhance efficiency in our work. When we use technology, it must be used in a safe and responsible manner. We try our best to use available, reliable technology in AI, but of course there are limitations. It can help us with identification, but then how to deal with the identified problems, it would still take traditional methods to do that. And sometimes information may not be readily available online. For example, for very old legislation, then there would only be paper format. We will need to provide this information to the technology or train up the AI, and therefore this would take some time. Be rest assured, however, we would make wide use of technology to help us with enhancing efficiency. How about for the e-legislation database? Could you improve it, or how about information on the fines? Ms. Chen. Let me try to give you some background information. In each legislation, there is certain penalties. Our intent is that when we propose amendments in a central manner, then we wouldn't need to make changes to the fines in each and specific legislation. Well, you asked whether we could make this clearer. I would take this back and discuss this with my team to see whether this is possible. Thank you. Now, if there are no other policy-related questions, we now move to the clause-by-clause scrutiny. The bill proposes amendments to multiple legislation and subsidiary legislation under various policy bureaus, and quite a number of these amendments fall within the remit of the same policy bureau. Well, in order to facilitate members to focus discussion on certain similar amendments or amendments pertaining to the same policy bureau, administration suggests that we could look into the comparison table issued by the Secretariat on August 11th and the marked up copy by the Legal Service Division, LC paper number CB bracket 3948/2026 bracket 02. I'll also like to invite the government representatives to take turns to brief members on the policy aspects of the amendments for which they're responsible and lead members in scrutinizing the relevant clauses. So please tell us which page on the marked up copy you are referring to in both Chinese and English versions. And then we would go through the Chinese before the English, as that would be more systematic. I would like to ask members whether they agree to this suggestion. If you agree to look at both Chinese and English version together. While during the clause-by-clause scrutiny, legal advisor, please raise any questions or issues that you may have. And now we move to the clause-by-clause scrutiny. And members may wish to ask questions when we are on particular clauses. Well, first of all, we first invite members to look at the blue bill CB CB bracket 2923/2026. So we first look at the blue bill, page C1990 to C1993. Blue bill C1990 to C1993. I now invite Ms. Lorraine Chan to take us through the part 1. Thank you. Let me go through the long title. The Chinese version is on page C1990. A bill to make miscellaneous amendments to various ordinances. The English version is on page C1991. A bill to make miscellaneous amendments to various ordinances. I will take a brief pause every time we finish looking at one clause or one part, so this would give some time for members to ask questions if they have any. If there are no questions, sorry, Ms. Carmen Ken.
主席，
I'm seeking a confirmation. This is the third exercise. Is it the case that in the previous two bills, the long title is so short, that is, make miscellaneous amendments to various ordinances? So in C2712, that is the memorandum of explanation, that is just an aid. In that part, it's explained in detail. Just like in the legislative brief, it talks about amendment to a number of enactments, the references, to bring them in line with the basic law and in line with the constitutional basis of Hong Kong as a special administrative region of the PRC. So in the explanatory notes, it's more elaborated. However, in the long title, is just make miscellaneous amendments to various ordinances. So what are the considerations? Is it the same as the past two exercises? Yes, it's the same as the last two times. Our consideration for the long title is to be as succinct as possible in conveying the main message. Well, this exercise is not just for adaptation of law. We think that what we've proposed is sufficient to reflect our intent to introduce this omnibus bill. We elaborated it in our explanatory notes to enhance understanding of the policy intent of the exercise. Please continue. Deputy Solicitor General. Well, the first one is in relation to the commencement. Preliminary. First, a short title and commencement. This ordinance may be cited as the Statute Law Miscellaneous Provisions Ordinance 2026, bracket 2. Subject to subsection 3, that is Part 89. This ordinance comes into operation on the expiry of 30 days, beginning on the day on which it is published in the Gazette. 30 days is chosen because of the sheer amount of amendments. We need to give time to our law draftsmen to have sufficient time for editing. We want to have a comprehensive and complete e-legislation for public inspection. Bracket 3, Part 89. That is in relation to merchant shipping, safe and environmentally sound recycling of ships ordinance, that is Cap 657. We propose that this part comes into operation with the principal legislation. This part has yet to come into operation. So apart from Part 89, all other provisions will come into operation on the expiry of 30 days after it's been published in the Gazette. Continue, please. Clause 2. Enactments amended. The Chinese version is C1992 and the English version is C1993. It says the enactments specified in parts 2 to 100 are amended as set out in those parts. Miss Khan? The English word enactment. Chinese, it's 成文法. Is it in line with the legislation of Hong Kong, the laws of Hong Kong? Yes. Thank you. So we've completed C1990 to 1993. As I said previously, according to the proposed approach, we will make reference of the reference table and not in the order of the clauses in the bill. Members agree to this approach? So we will make reference to the list of reference. We'll ask Mr. Lee, Senior Government Counsel of the LRC, to take us through the list of reference. He'll ask relevant bureaus and departments to explain the provisions. Please first give us the page number of the Chinese and English version in the marked up copy, so that members can find the relevant page before you start the explanation. The legal advisor has asked questions on certain clauses. When you reach the relevant clauses, please give us your reply as well. We now hear from Mr. Lee. A word of reminder to Mr. Lee and BDs. if it's the same changes to the references with the same wordings, please use the same wording for the same amendments. Members, please refer to the list of reference of 15 pages with an orange heading. The first ones are those relating not arising from the systematic review. That covers Part 88, that is Cap 652. The Chinese page number in the marked up copy is 885 and 886. In English is 860 to 861. I will defer to the Development Bureau. Please give us time to go to the right page. Yes, please go ahead. Thank you. That is in relation to Cap 652, Construction Industry Security of Payment. Clause 49(1). Well, the relevant legislation came into operation last year. That is in relation to speed up resolution of dispute of payment. This will address the problem of long-standing problem of delay in payment. If the party to pay fails to make the payment as stated in the judgment under Section 49, the party may apply to the court to enforce the judgment. In the latter part of the scrutiny of the bill, the development, as per the request of the DOJ, proposed to make some changes. That if the amount is over $3 million, then an application has to be made to the CFI. Otherwise, the application should be made to the district court. All provisions reflect the policy intent, save and except the last part of 49(1). Currently, there is a reference of the High Court. It is consistent with other provisions. However, well, we think that the way it's written can be read that is in a way that is in line with policy intent. However, we want to clarify the legislative intent and to enhance clarity. Hence, we propose the amendment. If there are no questions, let's move on to the English version. Well, the English version is the same. It's just to change from the High Court to that court. Okay, no questions. Please move to the next part. That is in relation to Part 36. That is amendments to Cap 237, the Chinese version. Sorry, please pause here. Mr. So has some questions to ask. 49(1). The change. That court means the court that gives the leave and to give the order for enforcement. It says that may with leave of the court be enforced in the same way as a judgment of that court in its civil jurisdiction. So it means, well, just now you said that the court may be a district court. So it says, that court, what is the definition? I don't have the context. Does it cover the scope I just mentioned? I don't want that to be interpreted as the court that gave the leave. BD, please. As I said, there is the line of $3 million. Under it, the case is handled by the district court. The district court may grant leave for enforcement. If it's over $3 million, then it's to be handled by the CFI Court of First Instance. So depending on the amount, that may fall under the jurisdiction of a different level of court. It's clearly elaborated in the subsidiary legislation or subsidiary rule. Thank you. Mr. Lee? Ms. Kan? So, from what I heard from the Development Bureau, did they miss it? Is there a need to change it? Because, well, in the English, it's uppercase C, as Mr. So said. So, before the amendment, you thought that the reference to the High Court also worked. So is there a need to change it or not? Well, if necessary to change it because it was missed at that time, just tell us. Well, if you say that it still works without the change, then why change it? Mr. Tang. Most of the provisions have been changed to the court, and in the ordinance it specifies that the court may mean the High Court or the District Court. The original under 49(1) is the original intent, but with the legislative amendment, is changed. That's why we ask to change the reference from the High Court to that court.
Ms. Kan, well, if you look at it, well, it says it can actually be with the agreement of the court. So that would be, if that's over 3 million, then it would be seen as the CFI. However, if it's under 3 million, then it could be district court. So the Chinese term 法院 will note that the Chinese is just 法院, but then the determination made can be enforced in the same way as a judgment of the High Court in its civil jurisdiction, because I think that the original intent is still the same, because in English it does say that a determination made in education proceedings made with leave of the court be enforced in the same way as a judgment of the High Court in its civil jurisdiction. Is your intent that now that you have divided into the different levels of courts, then regardless of which court, the determination could still be handled like a high court? it seems that no amendment needs to be made. Did you miss it the last time? And so now you need to make a change, because I don't think that there is an issue with the original. Well, it's not that ideal before. There is a need to make this amendment. As I said, for under 3 million, it will be handled by the district court. And so any enforcement would be in accordance with district court. So there is a need to make the change. All right. Well, I hope that clearer explanations could be made when we are doing the clause-by-clause scrutiny, because if there is a need, tell us there is such a need. We don't want it to be too confusing. All right. Government representatives, please be clear and concise in the explanations. Well, for the court to be in uppercase, our legal advisor also has some comments. Well, I'd like to give some additional information to members. We noticed that under clause 22, under the construction industry ordinance, there's a definition there. So when there's a term court, it refers to court of first instance or a district court. So for Cap 49 is under Part 3, so it could be seen as district court or high court. So this is already listed out in the section under the ordinance. Ms. Khan, thank you, legal advisor, for your additional information. All right, so a change must be made because you have defined it as court of first instance or district court. So there is a need to make the change because the High Court is not included in the definition. Am I correct? Legal advisor, I believe High Court was used because it was from long ago. We would see the term High Court in other legislations. In accordance with Cap 1 of the Interpretations and General Clause Ordinance, High Court would be referred to 高等法院. But now there shouldn't be any problem, but since it is now defined what court includes, so the change needs to be made. So how do we define the High Court in our legislation? Mr. Lee, can you take this question? What is the definition of High Court? Well, there are other parts that may relate to the same amendment, right? Well, that is a bit more complicated. Perhaps when we are scrutinizing other clauses, then we can explain it further. We're talking about the legislation that was passed before 1997. For legislation before 1997, High Court then would refer to the all high courts under the HKS under Hong Kong, and that includes the CFI and district courts. But after 1997, High Court would refer to the High Court under HKSAR. There are some original legislation that includes the term High Court, but before the handover in 1997, High Court in Chinese was 高等法院, but then after 1997, that would refer only to CFI. So we would need to look at this clause by clause. We wanted to demonstrate that the High Court before and after 1997 is different. So when we see in legislations that refers to the High Court before 1997, we have to make it clear then whether we're referring to the High Court as with the definition before and after 1997. But for this particular legislation, it is actually after 1997. The legal advisor was referring to Cap 1 of the definition, which was already amended under interpretations and general clause ordinance. We're now actually using the definition of Section 3 under Cap 1. But then we also need to look at the annex of Section 8 of Cap 1. Well, we just want to make it clear in our provisions. Madam Chair, so for this particular ordinance, as High Court, here the court is already defined under Section 3, so that would not include the Court of Appeal. So that is the reason why the High Court must be replaced by the court in uppercase C. Am I correct in my understanding? Yeah, my understanding is that there is a need to make this amendment. Let me try to clarify this further. Section 22 shows a very clear definition of court. English says it means the court of first instance or the district court. Therefore, when we look at Section 49, bracket 1, when it refers to court, well, of course, we're looking at the determination made, and so we have to see whether this determination falls under court of first instance or district court. Due to jurisdiction, when a determination is to be enforced, when applicable, there should be a flexibility to show whether it is CFI or district court. The Development Bureau just now explain that to ensure that we follow the original intent of the ordinance, we must make this replacement. Alright, so we are referring to different levels of court, and there is a need to replace the High Court with that court. Mr. Holden Chow. Madam Chair. Oh, the explanation was very clear, but then it gives rise to another question that I have. Now let's first take a look at Chinese. In Chinese it says 在審查中所作出的裁定在法院許下. So in English that would be the uppercase, the court. Well, originally it was 高等法院. Now it is replaced by 該法院. My question is, from the explanation I heard from the legal advisor, let's say there is now an adjudicator. Well, because if you look at the English, we know that we're looking into what is done by the adjudicator. Let's say the adjudicator comes up with a determination. What I understand from the council is that if this is under 3 million, then you would follow the rules of district court. But then if it is above 3 million, then you would follow the determination by High Court. It seems very reasonable. But then if we look at the original wording, let's say that the enforcement methods differ from the enforcement application by the High Court. This here says that you should still be enforced in the same way as a judgment of the High Court, because with an adjudication application, even if you're talking about 2 million, you would still need to follow the enforcement by a High Court. I am just assuming that for some of the applications, the enforcement differ between CFI and District Court, but the original wording states that we should follow the judgment and the enforcement method by the High Court. But now with the change, you are actually dividing these into two different enforcement methods. Well, if there are no major changes between the two enforcements, then of course that's not a problem. But then if there are major changes between the two enforcement applications, then there may be an issue arising for that. I want to try to understand this further. Ms. Chen. Well, Mr. Chow is correct in his understanding of the original wording. And from the explanation we heard from the Development Bureau, it is because of this wording that it cannot demonstrate the original intent of the CFA. Let me give you some background information. So it was really this way before a CFA. There's actually no district court at that time. But then after discussion with the DOJ, it is decided more flexibility should be given, that when it exceeds a certain amount, then there should be a different enforcement application. Therefore, for Section 49, Bracket 1, our proposed amendment is to ensure that there is such a flexibility, because the original wording does not show this flexibility. We want to add this in, and therefore after we make this amendment, we will be able to include both the District Court and the CFI.
Mr. Dennis Leung. Thank you. The legal advisor talked about 657. It should be 652, not 657. The Development Bureau said that the amendment was not entirely necessary, but now you ask us to change it. I think you need to be very careful with what you said. Refrain from using contradictory words, please. I think this proposed amendment is based on Section 22 of the same chapter. It stated very clearly that the High Court refers to the CFI. That's why we need to amend this, because the case may either be handled by the CFI or the District Court. This will dispel ambiguity. I agree with Mr. Leung. I ask the bureaus or departments to be certain, direct, and clear. If you want it amended, just say so. Mr. Alex Fan. Well, talks about Section 22 of Cap 652. The court refers to either the CFI or the district court. I did not look at Cap 652 because we're here to talk about the Statute Law Miscellaneous Provisions Bill 2026. But if it is amended this way, would there be an ambiguity that the party may choose to enforce it in either level of court, because it doesn't say clearly that district court will handle cases of an amount under $3 million. I don't know if I have gone off on a tangent. When it comes to enforcement of adjudication, then I think about Cap 657 and 609 or Cap 319. Because when it comes to arbitration and reciprocal enforcement, the case has to go to CFI because of certain reasons. I don't know about those reasons. But now, if you change the word High Court to court to bring it in line with Cap 652, does it clearly say that when it will go to which court? I wonder what the consideration of the department is. I believe that it was explained in the discussion. When it comes to the exercise of civil jurisdiction, if it is read that in a way that makes it clear whether the case goes to the CFI or the district court, then 49 is clear, because in the district court ordinance or the high court ordinance, there is a clarification, or the amount is clearly stated in the respective ordinance. We think that it is the way it's written is clear enough. If in the future there is a change in the monetary amount of the civil jurisdiction, there is no need to change this as well. So the party cannot choose under Cap 652. If it falls within the jurisdiction of the district court, then it must be handled by the district court. If the amount is below $3 million, then it can't go to the CFI. Should it be clarified? If it is under jurisdiction of the CFI, then it must go to the CFI without giving the parties the choice. I think if the party cannot choose, then please state so. I don't think there is no ambiguity. We want to get rid of all ambiguities here. I think that the administration has heard you. Mr. Tang? Yes. In the rules of Construction Industry Security of Payment Ordinance, under Rule 4, it's clearly stated that if it is under the amount of $3 million, then the application for enforcement will have to be made to the district court. Otherwise, it is to the CFI. So it's very clearly stated. So it is stated in the rules. Yes. Thank you then. Mr. Wong? From what I've heard, it is necessary to make this amendment, but I have a question on principle. Is it within the scope of the bill? it's not the case that it has to be adapted. I just want to make sure that it is within the scope of the long title of the bill. Ms. Chan, as I've explained, it's a regular exercise of the government over the years that in relation to this kind of amendment. It's not adaptation related. If it is a minor amendment and if it is not controversial, it will be done by way of Miscellaneous Provisions Bill. This amendment is to reflect the legislative intent of the CSA. It is not controversial. The way the long title is written covers minor non-controversial amendments, so it is within the scope of the long title. Thank you. Please continue, Mr. Lee. To make things more efficient, perhaps after we have heard from the administration, question and answers of members will be limited to 4 minutes. If necessary, we will extend it. Mr. Lee. Now we move on to the next item. Part 36 on CAP 237, Fixed Penalty Traffic Contraventions Ordinance. You'll find the relevant part in Chinese, page 369 to 370, in English, 339 to 340. I'll hand over to the TLB, Ms. Choi. Thank you. This is to make consistent the updated title effective from July 2024. That is to replace OGO with the Commissioner of Digital Policy. It is under section 15AA(e) of CAP 237. There is a relevant amendment in the English version. You'll find the information on page 339 to 340. This is to replace the wording of Office of Government Information Officer with the Commissioner of Digital Policy. So it's bracket 2, bracket B. You will have to state the information so that it will appear in the record. Is CAP 237 15AA(e) bracket 2 bracket B as well as bracket D. Give some time for members to go through it. Mr. Lee, please continue. Sorry, Ms. Khan. (15AA(e). When was it added to CAP 237? I mean, when did 15AA(e) added? When was it added? It says is Legal Notice number 13 of 2024. By this notice, the section 15AA(e) was added. Is it the case that at that time, when the provision was added, Commissioner for Digital Policy has already come into existence? The new title came into operation in July 2024 in relation to changing the job post title of a series of posts, including the Commissioner for Digital Policy. It says that starting from the 25th of July 2024, these new post titles will come into effect. And before this legal notice came into operation, the Miscellaneous Provision Bill was not passed by the legislature yet. That's why this title was not included in the last lot or last batch. So in the first exercise, that is in 2024, it was not included, and now you're going to include it in the current exercise. Is that right? Yes. Next is Part 37, an amendment to Cap 240. It's in page 370 to 371 in Chinese, and in English, page 341 to 342. It's the same as last time. That is, to replace Government Chief Information Officer with Commissioner for Digital Policy. This is in relation to requirements specified for digital signature under Section 388D(7). It is in Section 388E. You will find the relevant amendment in 2B and D. Please give us the page number, the cap number, as well as the number of provision. Is Cap 240, so Section 388E, 2B and D. So clause number is 153. Please continue. That's it. Mr. Lee.
Next, it is on Part 58, clause number 359. So this is in the Chinese version is on page 704 to 705, and for the English version it's from 697 to 698. Miss Brittany Choi. Thank you. So this is for so this is actually the road traffic ordinance and its subsidiary legislation, which is in Cap 37460 in relation to also to replace the Government Chief Information Officer with Commissioner for Digital Policy. Mr. Lee, please continue. Next, we would now move on to the amendments arising from the systematic review. So we're going to first on Cap 448 sub legislation C, which is clause number 393. So this amendment only involves an amendment in the English version. So this would be on page 746 to 748. May I now defer to Mr. Wong? Thank you. So this is now this is Part 68, Air Navigation Hong Kong Order 1995, Cap 448 sub Leg C. So this only involves the English version. So please refer to the marked up copy, page 746. Here we suggest repealing 2, clause 2, bracket 2, because this is already outdated legislation. At that time, when we set up the 1995 air navigation, it was some sort of a transitional legislation, and now it is outdated. And under 2 bracket 1, in relation to subject to paragraph 2, which is the reference of the previous paragraph, it should also be repealed as it is outdated. Mr. Alex Fan. Well, this one relates only to the English version, so I took a look at the legislation. I found that there is actually no Chinese version of this order, and I'm actually quite astonished to see that there is only an English version of this order. So are there many other legislations that only has an English version, or is it only specific to Cap 448 sub-C? Why? I think this is out of the ambit of the clause-by-clause scrutiny. Or perhaps I should ask this way. Why is there no Chinese version to Cap 448 sub-C? Mr. Wong, yes, there is only an English version for Cap 448 sub-C because this is a very complicated subsidiary legislation. It involves many regulations on air navigation. It would take a very long time to translate it into the Chinese text. And at this time, we're looking at the adaptation of laws. We are also working on the Chinese version of this subsidiary legislation. Mr. Holden Chow. Thank you, Madam Chair. I'm also quite shocked that there is no Chinese version under the legislation. Well, Mr. Fan's question was exactly what I wanted to ask. Well, the administration said that it is very complicated. Well, I don't think this is an excuse that we accept. Even if it's complicated, there should be a Chinese version, right? I'm not asking you to do this immediately. However, you should take the effort to translate it into Chinese. Or is this a next step for your department to do? Or I don't want to deviate too much from our discussion today. Let's just focus on Cap 448 sub-C, that there is no Chinese. I hope that you would work on this very soon. Thank you. Well, let's ask the administration to provide a written submission to us on legislation that does not have a Chinese text and give us an explanation. Ms. Carmen Ken. Madam Chair, I also have the same question since there is no Chinese text. When we amend 393, so why do we have to look at both Chinese and English text, and why would we use Chinese to amend a subsidiary legislation that does not have a Chinese version? I'm referring to page 2588 of the Blue Bill, that there should be both Chinese and English. Well, I could defer this to the DOJ. Thank you. Well, although there was no original Chinese version of Cap 448 sub-legislated C for the Statute Law's Miscellaneous Provisions Bill, we do need a Chinese version, so we cannot jump over 448 and exclude it, because that would not be ideal. for all our new legislations, we do need both Chinese and English versions. So we would need to include a Chinese text under the Statute Law Miscellaneous Provisions. Well, CC Cap 448 is quite unique because there are no such Chinese texts. But then for amendments made only in one language, then we'd also make this very clear. This is actually our usual practice. Well, thank you for asking for a written response. I do want to know the method in which they're going to adopt in formulating the Chinese version. Well, I hope the administration will provide us with a written reply on how you're going to take this forward and whether there would be a timetable and why there is no Chinese version to this English legislation, and we cannot accept you using Chinese to just use Chinese to make changes or amending the English version. Mr. Dennis Leung. Madam Chair, I also have a question on that. Well, last year when we amended Cap 448C and Cap 448G, members also have a similar question. Well, the administration said that a Chinese version would be provided, but I don't believe that this could be done very soon. The entire Cap 448 does not have a Chinese version. Well, I don't think it can be completed within this term of government. I hope that the administration can explain to us that why, since the legislation came into effect in 1995, no Chinese text has been provided for so long. All right, we look forward to a detailed explanation from the administration for us to understand the current situation. Mr. Lee, please. Thank you. Next, we now move to Part 75, Clause 4282429 in relation to carriage by air ordinance Cap 500. The Chinese version is page 803 to 804, English 791 to 792. We continue to defer to Mr. Wong. Thank you. So this is Part 75, Clause 428 to 429 on the amendment to carriage by air ordinance. First of the Chinese marked up copy is on page 803 to 804. We are going to make amendments to 12 to replace the governor with chief executive, and then the Chinese copy. I'm sorry, can you also tell us whether it's 12 bracket 1 or 12 bracket 2 in the Chinese version, because we could to make it more clear. Well, yes, for 12 bracket 1 we would take out those outdated areas, and then in 12 bracket 2 the term the governor appears twice, and we would replace it with chief executive, and then we would also repeal the outdated versions. All right, please continue to the English version. Well, it is in marked up copy, page 791. And same with the Chinese version. Under 12 bracket 1, we would take out the references there, and then under 12 bracket 2 we would use chief executive to replace the governor and take out the references at the bottom. Oh yes, the term the governor appears twice here. Ms. Carmen Can, thank you. Well, this part refers to the Montreal Convention, and so we have to make clear which area comes into effect. So I want to ask about why there is a need to replace the governor with the chief executive. Has this actually been used or has it been applied? Why is there a reason that we are making the amendment now and not before? Mr. Wong, well, we had to take some time to replace the governor with chief executive because we had to do a bit of research before that, because this is actually on the application of carriage by air. The chief executive with this amendment will be able to waive parts that are not applicable. You are correct. This is not very often used or applied. We just want to make consequential amendments. We are doing this now because we do need to conduct an in-depth research on this ordinance. Well, if we look at the marked up copy of page 803, it says that it is amended in 2005. So can I understand that it hasn't been used or applied since 2005, and that's why you didn't need to consider earlier why we have to replace the governor. Well, so can you tell us whether it has been used since 2005? No, it has not yet been applied. So when the secretary was introducing the amendments, you have to make clear to us the definitions, and then on what terms we use to replace the original terms, or how we replace the Crown with HKSAR government. I know it takes time, but when you were giving explanations, you have to tell us why you're raising this today and not before. You have to give us reasons why this hasn't been amended for so many years. Perhaps you can tell us outright that you haven't applied this in 20 years, and since we are now looking at the omnibus bill, we can now smooth out all the legislation, because with this amendment we should not see any terms like the Crown or UK after these amendments.
Mr. Dennis Leung, apart from replacing governor with chief executive, there is also some deletion of appendix information. Why? Administration. The information in the square bracket is information that cross-reference to UK legislation. It is outdated, hence the deletion. You have not covered page 804 of the Chinese version. Yes. This is section 9 of the carriage by air ordinance. There are a number of amendments. 19(1), the amendment to replace the Crown with the government. And 19(2), the word Crown appears twice. They will be replaced with government. And there is also an information in a square bracket. As I said, that's a cross-reference of the UK Act. It's outdated and will be deleted. 19(3), there is the word Crown. It will be replaced with government, and the information in the square bracket will also be deleted. Now we move on to the English version. It's page 792 of the marked up copy. Just like in the Chinese version, 19 bracket 1, crown will be replaced with government. Bracket 2, there are two references of crown, they'll be replaced by government. And the cross-reference in the square bracket will be deleted. 19 bracket 3, crown will be replaced by government, and the cross-reference in the square bracket will also be deleted. In part 3, you said that, Montreal Convention has not been invoked since 2005. But part 4 should have been in effect the whole time. So what's going on with this provision? Why there was not a need to make the amendment? Mr. Wong, it's not the case that we did not think it was necessary to make the amendment. We have been in deep discussion with the DOJ on how to amend the word crown. We make the proposal after careful consideration. The provision has been in effect the whole time. So can you tell us why now you think it is appropriate to replace crown with the government? The background of the carriage by air ordinance is that it is about the application of international convention in Hong Kong. We need to replace the word crown with government. It depends on what the provision is applied. We have considered different alternatives. We consider the legislative intent, the original intended scope of application. We've also considered actual operation. We think that the replacement by government is appropriate. It's not detailed enough. What alternatives have you considered before you decide on government? We need to know why you think it is an appropriate choice. Do you have further explanation? Otherwise, you just give us a written reply. Secretary. The approach is the same as when we handle the word crown in other provisions. The word Chinese 官方 has no problems, but however, the English word crown may mean the UK government or the then government of Hong Kong. So every time when we have to address the issue of crown or 官方, we have to clarify whether it only applies to the Hong Kong SAR government or the central authorities. Sometimes it may be referring to central organs in Hong Kong. This involves different international conventions. Our understanding from the Bureau is that the relevant convention is in relation to Hong Kong as a separate party. Different provisions of the different conventions may refer to different parties, so we have to clarify whether it applies only to the Hong Kong SAR government. In this case, it's decided to replace crown with government. I think it's a very good explanation and it helps us. You need to explain to us what you have considered before making the decision and why you think it is appropriate. We can see that it is a replacement. But you need to tell us your rationale. And you need to explain to us why you think this is the right choice. Perhaps after the department or bureau have explained to us, maybe we'll also hear from the secretary as well. Thank you. Next, we move on to Part 2. Amendments to Cap 1 Interpretation and General Clauses Ordinance. It involves clauses 3 and 5. In the markup copy is pages 1 and 2, and in English is 1 and 2, as well as pages 5 to 9. We'll defer to Ms. Lee of the Chief Secretary's office. Thank you. The first one is in relation to interpretation of words and expressions under Cap 1. Please refer to page 1 of the Chinese version and page 2 of the English version. Is in relation to 3(2), that is, statutory declaration. Under bracket C, the current wording is Mainland of the People's Republic of China. So if it is in relation to Hong Kong, the reference of the PRC should be Chinese mainland. And C is with reference to Hong Kong. So we propose that the term mainland of the PRC is to be replaced with Chinese mainland. In Chinese is 中華人民共和國大陸 to be replaced with 中國內地. Please continue. The next one is the same. Section 3 of Interpretation of Words and Expressions is the definition of joint declaration. It's on page 2 of the Chinese version and in English page 1. The definition of joint declaration is not used in other provisions. We think there is no need to refer to the joint declaration in new legislation. The term joint declaration in English version is not the full official title. As there is no need to use this definition again, we propose to repeal the definition of joint declaration under Cap 1. Mr. Fan. The issue of the reason of repealing joint declaration. Joint declaration appears in Cap 1. Is it because of referral of the definition? Is it the case that in the past joint declaration was referred to in other provisions, and as time has changed, this is no longer the case? Or is it the case that it's never been used in any other provisions from the beginning? Perhaps we'll hear from the Secretary first. Let me give you some background information before the Permanent Secretary supplement. When this was added in other provisions, the short form joint declaration 聯合聲明 was used. So there was a definition and interpretation under Cap 1. In our systematic review, we found that the term does not reflect the full title, and in other provisions, the full title was not correctly cited, and in some other places, the short form was used. We think that the chance of it being used again in the future is slim. We think that it is not appropriate to amend the interpretation. While we delete the definition in Cap 1, if necessary, when this is cited, we will use the full official title of the joint declaration. That's why we think there is no need to define this in Cap 1. Thank you, it's very clear. Next, Ms. Khan. When it was defined in Cap 1, the Chinese is 聯合聲明 joint declaration. How come the official title was not used at that time? If you find the information, please let us know. Of course, I support this amendment. The name has to be the same as the full title. But how come in the first place that the official title was not used in Cap 1? It is not the case that it is no longer used, that's why you propose to delete it. It's used. You have explained that joint declarations used in other provisions. It's just that you will state the full official title instead of just saying joint declaration in other provisions.
Well, actually, there's a very long-winded explanation. I'll try to be concise because this involves more than 2 countries. And under this situation, it does involve over 2 countries. We see that some definition, then they would put a British first, some would put a Sino first. Well, after seeking the advice from the central authorities, we understand that we usually we would put our own country first, whether it be Chinese or English, and therefore what we do now is to put China or Sino first. Mr. Dennis Leung, I would wait till we move on to the English version because there are English amendments. Could you now explain to us the English amendment? Well, you've already said it before, but please take us through this again briefly. Well, the English version, we also suggest to repeal it joint declaration from the Interpretation and General Clauses Ordinance, same as the Chinese version. So on page 1 of the English marked up copy, there's still other amendments. I think there is one on Macau, right? Can I move on to the amendment to Macau? Well, yes, if there are no other questions on the joint declaration, then we can move on to the section on Macau. Thank you. The next amendment relates to the spelling of Macau. If you can look at page 1 of the English marked up copy. This is under clause 3 under cap 1, interpretation and general clauses ordinance, and in paragraph 17 and 18 of our annex, we see the term Macau. The current spelling is M-A-C-A-U. M-A-C-A-U appears in official Portuguese texts, such as the Basic Law of the Macau Special Administrative Region. But in English rendition, then they would usually use MACAO. We therefore suggest to use MACAO as this appears to be more appropriate for use as the English rendition for Auckland, as the government of the Macau Special Administrative Region also use that in their English publications. Mr. Dennis Leung. Well, the spelling of Macau is to be changed here. I see that under one country, two systems principle, we see that Hong Kong is very stated clearly that there is Hong Kong SAR, but then for Macau, they do not add in the Macau SAR. Even for Taiwan, only Taiwan will be used. I would like to ask the DOJ, under the current circumstances, is it that SAR will only be added to Hong Kong, and that for Macau and Taiwan, they would only use Taiwan and Macau without adding in SAR? Secretary, it depends on the application of each legislation. When we refer only to the geographical location, we will not add in SAR. Macau is more unique. After the handover, some legislation differs because their handover is after the Hong Kong handover. We cannot just add in SAR to all the Macau legislation because some of the legislation still refers to Macau before the handover. Therefore, we have to look at the legislation one by one. We believe that it is more appropriate not to add in SAR for Macau. Therefore, we have only put in the word Macau. Secretary, this is the third round of amendments. Did you adopt the same approach in the previous two rounds? Well, yes, we made changes to the spelling and also made similar considerations. Ms. Carmen Ken, my concern is similar to that of Mr. Leung's. Let's first talk about Macau. Is there a definition of Macau in Cap 1? Because we are now looking at Cap 1 at the moment. Is there actually, for under the definition of 中華人民共和國, we would include SAR to Hong Kong? Well, there's a definition of Hong Kong under Cap 1. Hong Kong is defined as Hong Kong SAR. Well, it's under the same cap. It's all under cap 1. Hong Kong itself would mean Hong Kong Special Administrative Region. When we talk about People's Republic of China, why do we have to write it again? Yet there is no such as SAR added to Macau. Secretary. Under the current legislation, there is the definition already in place. If you look at the supplementary information, so this was actually handled in Cap 1 under Interpretations and General Clauses Ordinance. There is a retrospective effect, and there is a definition of Hong Kong which was decided to remain unchanged. And then you can see that SAR was then later added as a supplement. Perhaps the government draftsman can also provide us with some information that there may be repetitive situations when we do not want when we don't want to see controversies. Madam Chair, I'm sorry, there's a definition of Hong Kong Special Administrative Region that the Chinese is written as 香港特別行政區. Well, I'm now looking at the English version. The geographical extent, it says that the Hong Kong means the Special Administrative Region of People's Republic of China, and the geographical extent that may refer to in Schedule 2. So now you're trying to define the geographical area. Am I correct? You're trying to show the geographical extent. If that's the case, why would you not also put in the geographical extent for Macau? Secretary. In some circumstances, we have to be clear of what the Hong Kong Special Administrative Region refers to. And there is a map in the original legislation. We're now using the definition under the State Council's order number 221. And my understanding is that we want to show the geographical extent of Chinese mainland that includes Hong Kong, Macau, and Taiwan. This is to ensure that when we refer to People's Republic of China, we are referring also to these inalienable parts of China. All right, thank you. Mr. Augustine Wong. Thank you. I also have a quick question. In Cap 1, there is a lot of English amendments, and there is no mention of that in Chinese, which differs from another legislation that even if there is only an amendment made in English, you need to have a Chinese text to ensure its comprehensiveness. But here, there is no change made to the Chinese. Is there a need to make amendments as well? In the blue bill, we must have both Chinese and English. And now we are looking at the marked up version. If there is no change in the Chinese text, then it will not be shown on the marked up version. All right. Please continue with page 5 to 9 in the English version. Thank you. I'd like to add on to Macau. In the blue bill, in clause 5, there's a mention that there is a change to the spelling in Macau in English. Well, I think this is all I have to say for my part of the explanation. So that covers pages 1 to 2 and 5 to 9 in the English version. All right, please continue, Mr. Lee. Next. Oh, sorry. I would like to go back first. On the joint declaration, well, as you have removed the whole definition of joint declaration, so if there is a mention of joint declaration in other legislations, then you would use the official name of the joint declaration. Am I correct? So that means that there needs to be amendments made to all mentions of joint declaration. I think we will amend all this in this round. Thank you, Mr. Lee. We now move to Part 99, Hong Kong Reunification Ordinance, Clause number 490. Please refer to the Chinese marked up copy, pages 910 to 911, and English version, pages 882 to 883. Ms. Lee, please. Thank you. On the amendment of the Hong Kong Reunification Ordinance, this is similar to the joint declaration. So if you can refer to Chinese marked up copy, pages 910 to 911, and English version, pages 882 to 883. So the first part is we see the term the joint declaration. In the Statute Law amendment this time, we would amend some of the terms. So here you would see changes made 在1984年12月19號 to make it to change to U, and from U 北京簽署 change to 在北京簽署, and for the English version, from signed at Beijing, it will be amended to signed in Beijing. These would be consistent with other proposed amendments this time.
Oh, Ms. Kan, I'd like to get a confirmation from the Secretary. The use of the official full title. And the explanation that the order of the countries of the name when used by respective countries, is that in line with the other provisions? Yes. Mr. Dennis Leung. The Chinese version. It's a change of the word from 在 to 於 in. Also, in front of the word Beijing, it's a change from 於 to 在. But in some other provisions, it may be the word 在 is used in front of a date. So is there some kind of adopted approach when it comes to the use of the words 在 於 in front of a date in English? My understanding is that we follow the original name. In other situations, of course, there are other considerations. Mr. Lee, please continue. The next one is Part 57, Clause 358, an amendment to Cap 372 Subleg B Kowloon Canton Railway Corporation by law. It doesn't apply to the Chinese version. For the English version, please turn to page 696. We'll hear from Ms. Choi of the TLB. Ms. Choi, please. This is to maintain consistency with the official name. We propose to change 16A bracket 1 and bracket 2 of Cap 372 Subleg B. We propose to replace mainland China with Chinese mainland. Does it appear 3 times? Yes. Together with the heading of 16A, there are 3 places. Yes. The next one is Part 86, Clauses 4712, 472. Is an amendment to Cap 601 West Kowloon Cultural District Authority Ordinance. It doesn't involve the Chinese version. The English version, you'll find it in page 852 to 855. We hear from Mr. Choi, Permanent Secretary of the CSTB. That is Part 86. In relation to 2 sections of the Chinese names, that is Section 4 and Section 6. The first one is a 4 bracket 2 bracket J. Chinese of mainland will be replaced with Chinese mainland. This is to bring it in line with the official use of the term. The second amendment is on page 854 of the English version. The same chapter, 6 bracket 3 bracket C bracket Roman 1 and bracket A. Similarly, is to replace mainland of China with Chinese mainland to bring it in line with the official use of the word. Ms. Khan. Thank you. Please clarify. It doesn't involve the Chinese version because the Chinese version is correct, is 中國內地, so there is no need to change anything. It's just to change the English version from mainland of China to Chinese mainland. That is in relation to the 2 clauses you have mentioned. Yes, that is clause 471 to 472. Next one, please. This is Clause 7, Part 3, Amendment to Cap 2, Subleg A, Capital Works Reserve Fund. Please refer to Chinese version, pages 6 to 8, and English version, pages 11 to 13. We will hear from Ms. Mann of the FSTB. So, Cap 2A, Section 3. We will introduce a technical amendment to reflect the official name so that the official term will be used. Can you start with the Chinese version, page 6? The Chinese amendment is 聯合王國政府與中華人民共和國政府於1984年12月19日在北京簽署的聯合聲明附件3第6條的規定通過由聯合聲明。It will be changed to 於1984年12月19日在北京簽訂的中國人民共和國政府和大不列顛及北愛爾蘭聯合王國政府關於香港問題的聯合聲明，聯合聲明附件3第6款的規定通過由聯合聲明。Please continue. In the English version, page 11, the English version will be changed from under Section 3, the Joint Declaration of the Government of the United Kingdom and the Government of the People's Republic of China signed in Peking on the 19th of December 1984. We'll change it to the Joint Declaration of the Government of the People's Republic of China and the Government of the United Kingdom of Great Britain and Northern Ireland on the question of Hong Kong signed in Beijing on 19th of December 1984, bracket Joint Declaration. Mr. Lee, please continue. Next is Part 12, Clause 60. It is amendment to Cap 36. In Chinese, please refer to 112, and English is 111. We will defer to the Protocol Division, Mr. Seal. This is an amendment to Privileges and Immunities Joint Liaison Group Ordinance. It is the amendment to the definition of a joint declaration. You will find it in on page 112 in the Chinese version. That is 聯合王國政府與中國人民共和國政府於1984年12月19日在北京簽署的聯合聲明。附件3第6款的規定通過由聯合聲明 change it to 由1984年12月19日在北京簽訂中國人民共和國政府和大不列顛及北愛爾蘭聯合王國政府關於香港問題的聯合聲明通。In English, it will be changed from Joint Declaration means the Joint Declaration of the Government of the United Kingdom and the Government of the People's Republic of China on the questions of Hong Kong signed in Beijing on the 19th of December 1984. To Joint Declaration means the Joint Declaration of the Government of the People's Republic of China and the Government of the United Kingdom of Great Britain and Northern Ireland on the question of Hong Kong signed in Beijing on 19 December 1984. Well, there is some words in quotation. How many times has it appeared? Well, it appears in staff, experts, liaison group, and other parts. Miss Khan, sorry, I'm lagging behind. 006 Chinese version. This is to make it consistent. There is also the reference in the Chinese version 附件3第6款 but it's dispensed with in the English version. Because it's already mentioned before the amendment. However, in the Chinese version, in the original, is a Roman 3 referring to the annex, but it's a Chinese 3 referring to the annex. So, why? Was it wrong originally? Administration. Page 6. Please turn back to page 6. That is in relation to Capital Works Reserve Fund. Which is the responsible department or bureau? When we change the Chinese version, withdrawn reference from the advice of the DOJ. Perhaps we'll defer to the DOJ. DOJ? Or the Secretary? Or the Bureau? We will go back to look at the annex to see how it's worded. We will provide an answer in the written reply. Okay, a written reply. Mr. Lee, please continue. Next is Part 98, Clause 489. An amendment to Cap 1164 Hong Kong St. John Ambulance Incorporation Ordinance. You will find in the Chinese version 908 to 909. In English is 880 to 881. Would defer to the HHB, Ms. Chen. This is about Cap 1164 Hong Kong St. John Ambulance Incorporation Ordinance in relation to joint declaration. It is in G in the preamble. In the Chinese version, it originally reads 香港主權將於1997年按中華人民共和國政府和大不列顛及北愛爾蘭聯合王國政府關於香港問題的聯合聲明所作的規定移交。It will be changed to 中華人民共和國按於1984年12月19日在北京簽訂的中華人民共和國政府和大不列顛及北愛爾蘭聯合王國政府關於香港問題的聯合聲明所定規定，於1997年7月1日恢復對香港行使主權。The corresponding amendment in the English version is page 880 to 881. It will be changed from change of sovereignty in 1997 as provided by the Sino-British Joint Declaration on the Question of Hong Kong to resumption of the exercise of sovereignty over Hong Kong by the People's Republic of China with effect from 1st of July 1997 as provided by the Joint Declaration of the Government of the People's Republic of China and the Government of the United Kingdom of Great Britain and Northern Ireland on the Question of Hong Kong signed in Beijing on 19th of December 1984. Thank you.
Ms. Carmen-Can, thank you. Well, the focus here is to transfer the exercise of sovereignty over Hong Kong. So in English, it's the change of sovereignty to amend it to become resumption of the exercise of sovereignty. In this amendment, will you actually make this consistent across all the legislations? Secretary. Yes, thank you. Oh, this is actually a private ordinance. My understanding is that it only appears in private bills. Well, this is actually the Hong Kong St. John Ambulance Incorporation Ordinance. Therefore, at that time, it was raised as a private bill and passed. So this was not a bill raised by the government. And so that is the reason for this kind of error. Well, yes, that's one point. And also, this was actually enacted before the handover of Hong Kong. Secretary, so there is only this one bill, one ordinance with this issue. Yes, correct. Mr. Lee, now we move on to Part 26. Clause 1212122 in relation to registration of persons regulations Cap 177 sub ledge A. So So for the Chinese marked copy, it's pages 270 to 273, and English version pages 240 to pages 243. Ms. Hui from the Security Bureau, please. Thank you. Part 26, with registration of persons regulations, we proposed to make some technical amendments. So there are actually 4 groups of amendments. First one is on what we suggest to amend Cap 177/A in Chinese. On page 270, we suggest that 猜字 to be amended to 配偶, and for English, to page 242, we propose to change to replace wives with spouse. Let me continue to the second group. So this also relates to 25 bracket B bracket 2. So Chinese page 272 to amend 聯合共和國府 to change to 中華人民共和國中央人民政府或其他主管機關 and then for the English, then we would make the amendment from Her Majesty's government in the United Kingdom to the Central People's Government or other competent authorities of the People's Republic of China. Mr. Dennis Leung, other than the amendments, well, we can see that there may be different interpretations. Well, currently, Clause 25 said that for dependents, they're under 18 years of age, but then for some places they may say 未滿18歲. Sometimes it's 不足18歲. Is there a standard format, or would you actually make this consistent or standardize it? DOJ, please. Thank you for your question. Well, it depends on the text. For different legislations, we may use different wordings. So you're saying that 不足 and 不等 are separate meanings. No, 不足 and 不等 may mean the same, because in certain circumstances, we may use different wordings to make the content smoother. So there is no standardized format. Ms. Carmen Ken, I suggest that when you take us through the amendments, please also give us an explanation. Well, you suggest to replace 猜字 with 配偶. Because now even in the Chinese Liberation Army, there may be women officials as well. Well, 聯合王國政府, of course, it's not suitable nowadays. You are replacing with 中華人民共和國中央人民政府或其他主管機關. Can you tell us the reason for making this change? Thank you for your question. Your understanding of 猜字 and 配偶 is correct, because we want to make it clear that it's the spouse of the person, and so we want to be neutral in gender. Therefore, we would use the term spouse instead of wife. 聯合王國政府 is already outdated. So according to Cap 1 Annex 8 of the Interpretations and General Clause Ordinance, in accordance with Basic Law Article 160, in Cap 1 Annex 8, well, when we refer to the crown, the queen, or there are similar wordings, and when it involves the central authorities or involves the relation or organizations related to Chinese mainland, then we have to make clear of that. And after consulting DOJ, we suggest to replace 聯合王國政府 with 中華人民共和國中央人民政府或其他主管機構。Madam Chair, once again, we can see the amendments. Please, when you take us through the amendments, give us a clear explanation to help us with our understanding. Yes, please take note of that. We want to be highly efficient and to help members with understanding. Please provide a brief and concise explanation of the amendment. Mr. Alex Fan. Thank you. Well, currently, you said you're going to use the term 中華人民共和國中央人民政府或其他主管機關。I looked through Cap 1 just now. There is no clear definition of this term. I'd like to ask about the 其他主管機關 or other competent authorities of the People's Republic of China in English. What is the original intent? Are you just referring to those under the central authorities? Does that also include authorities under the provinces as well? Ms. Ho, thank you. For the Central People's Government or other competent authorities of the People's Republic of China, or for the registration of preference regulations Cap 177 subledge A, what we want to cover is that for those people who are employed by the Central People's Government or other competent authorities of the People's Republic of China, then they are not required to register or apply for the use of an identity card under this ordinance. This would be the employees of the Central People's Government or employees under authorities of the People's Republic of China. Those people should actually have a work visa issued by the State Council of the People's Republic of China. So we would use that to differentiate these employees. A follow-up, please, Madam Chair. This does not seem ideal. So I checked the DOJ glossary online. For example, Cap 1, Section 3, interpretation. So there are some. There are also some referring to organizations or authorities under the People's Republic of China. Well, if we are using this on a frequent basis, would you actually make this a clear definition under the registration of persons regulations? Otherwise, we could try to move all these commonly used definitions into Cap 1. Otherwise, you should just define it under the interpretations and general clause ordinance. I hope that the DOJ will consider my suggestion. Thank you. Secretary. Well, these are actually exemptions mentioned here, and it does not occur often. That's one situation. And secondly, last year, we also handled similar problems on as well. We have, which is on Cap 460, we have already consulted the relevant bureaus. And they support such an interpretation, and there should not be any problem with enforcement. At the moment, therefore, there are no plans to make a definition for these under Cap 1. All right, I'd like to follow up on the registration of persons regulations. Well, from what I understand from the Security Bureau, we're focusing mainly on competent authorities of the People's Republic of China. Well, let's say an official from Beijing would not be included, and an official from a provincial authority would not be included. Am I correct? Well, let me add on to that. Well, it's very hard to cut it across the board. For people who domicile in Hong Kong for over 180 days, and they would need a work visa. So here we are referring to those who are domiciled in Hong Kong and working in Hong Kong for over 180 days. For employees deployed by the Central People's Government or other competent authorities, then we would look at what visa they hold. For an employee from a provincial government, then we would identify them by their work visas. I'm not concerned with the operation. Let's say if there is a regulation to provide an exemption, oh, please hold, because I see that it's already 11:58 and our meeting should adjourn at 12 and there are only 2 minutes left. As we have to complete part 26, I would like to ask whether members agree to extending the meeting by 15 minutes. Thank you. Oh, sorry, Madam Chair. I'm not asking about enforcement. I just think that we should be clear in our legislation. It seems a bit vague at the moment. Would you also consult different departments and bureaus and try to make this clear?
Administration. Is it for flexibility? Can you give us the specifics? We have considered different alternatives. We have consulted the DOJ. We have also consulted the central authorities. We think this is a more appropriate choice. Thank you. Mr. Oden Chow. Thank you. I have two comments. One's already mentioned by Ms. Carmen Can. The change from wives to spouses. The administration mentioned that whether is someone serving in the Chinese PLA or someone working in the office of central authorities, they may be female or male, so it will be clearer to state spouses instead of wives. And the other comment is that the Central People's Government or other competent authorities of the People's Republic of China. I heard the explanation from the DOJ. It is an illustration of why it takes time to complete the adaptation of laws. The change of Her Majesty's government in the United Kingdom would have to be thoroughly considered as to what the term was referring to. I believe that in this case, the DOJ has consulted the central authorities. This is about exemptions to be issued an identity card. So the change to the Central People's Government or other competent authorities of the People's Republic of China is clear. Of course, it doesn't apply to all other situations. As the DOJ said, that the change involving Her Majesty's government in the United Kingdom may involve different implications. They will have to carry out thorough research. I support this particular change. It's only an expression of opinion. Thank you. Mr. Dennis Leung. I have some questions about certain terms. Identity card. Under the basic law, the Chinese word has a different radical. But here, different radicals are used for the Chinese word. So this one, without the radical signifying its person, is it in order? Are the two words, one with a radical, one without, are they the same? Are they interchangeable? DOJ, thank you for the question. In newer ordinances, the radical without the word without the radical person is adopted. The basic law uses the word with the radical signifying a person. It is interchangeable, but we now adopt the word without the radical of person. Ms. Cunningham. The DOJ has given us very clear explanation. It's an appropriate change. Just now, someone mentioned about Schedule 8 of Cap 1. Competent authorities. In Schedule 8, the word is competent organs, but here it says competent authorities. Can you give us an explanation? You now use authorities instead of organs? Who is to take the question? Thank you. Where? Because paragraph 1, Schedule 8 of Cap 1, the word authority is used. The paragraph cited by the Security Bureau, that is paragraph 1, it uses there is the word of authorities, competent authorities. We have adopted the same term. In English, paragraph 1, or other competent organs. Well, I am looking at e-legislation, paragraph 1 of Schedule 1 under C. It says other competent authorities. Please bring it up anytime you want, Ms. Khan, if you identify anything. Sorry, we still have Mr. Alex Fan. The description in English is competent authorities. I think it is appropriate. If you refer to Basic Law, Article 22, it's competent authorities. In Chinese, in the Basic Law, it is a 主管部門. And it's also expressed as a 機關. So I'd like to ask, should we use 部門as stated in the Basic Law instead of 機關? The proposed amendment is appropriate. Mr. Fan, you'd like to continue? No. Please continue. The third group, please refer to pages 270 and 271, that is in relation to 25D and 25D2 under cap 177A. To replace in Chinese 他 with 個人. We follow the same drafting style. Under 25D, there are two references of 他, him or he. In English, please refer to pages 240 and 241. There are two references of he. We propose to replace them with the person. Please continue. The fourth group is section 1, is clause 122. That is section 25A of cap 177A is 25A bracket 2 bracket 3 and 25A bracket 3, 2 and 3. In Chinese is pages number 272 and 273. The proposal is to replace 內陸 with 內地. In English is to change mainland of China to Chinese mainland. This is to make it consistent with the official use of the word. Chinese version is page 272. There are 3 places, right? Yes. 273. There are also 3 places. 2 in page 273. On page 273, how many? 2. So under 25A, 5 altogether. What about English? It's on 242 and 243 in page number. How many changes? On 2423 and on page 243, 2. Any questions from members? You have completed this part? Yes. That's the end of part 26. Please go to page 240, exemptions. Have you already covered it? Yes. If there are no questions from members, then today's meeting is finished. In the next meeting, we will continue with the clause by clause from the Security Bureau Part 2. If there are any amendments from members and administration, please give us the proposed amendment in written form as soon as possible to the Secretariat for handling. I don't think there are any other business. The next and the third meeting will take place on the 15th of September and the 28th of September between 2 and 6. The Secretariat will issue a notice to members. There are no other business. The meeting is adjourned. Thank you.